Hey everyone, and welcome back to the Deep Dive.
Great to be here.
You've provided us with a stack of sources that are, well, incredibly timely
Yeah.
and frankly, vital for anyone trying to navigate, modern community life.
Yeah,
Especially if you're a parent or involved with schools.
indeed. And this deep dive takes us right into the heart of a really significant Supreme Court decision from June 2025. It's Mahmoud et al. V. Taylor et al.,
Right.
involving a school board in Montgomery County, Maryland, and a group of parents.
Okay, let's unpack this one. Our mission today is basically to distill this pretty complex legal opinion and, the concurrences and dissents too, into clear, understandable insights. We're going to explore what happened, the legal arguments, and really importantly, what this ruling means for you, for families, and for schools across the country.
Yeah.
Think of it as your shortcut to understanding a really important conversation that's shaping our communities right now.
Okay.
So, to really get into this, we need to set the scene first. Montgomery County, Maryland. Our sources highlight it as one of the most religiously and culturally diverse counties in the nation.
Yeah.
You've got a vibrant mix of Christian denominations, a large Jewish population.
And it ranks high for Muslim, Hindu, and Buddhist communities, too. It's a real melting pot.
That diversity really seems foundational here, doesn't it?
It's absolutely foundational to understanding the conflict. So the Montgomery County Board of Education, MCPS they're called,
Okay.
they introduced what they termed LGBTQ plus inclusive storybooks into the elementary school English language arts curriculum.
And this is for the youngest kids.
Yeah, kindergarten through 5th grade.
Yeah.
So, ages 5 to about 11.
And these weren't just randomly chosen books, right?
Yeah.
The materials show the board used specific criteria. Things like, is heteronormativity reinforced or disrupted?
Mm-hmm.
Which means, does it challenge the idea that being straight is the default?
Mm-hmm.
And also, is cisnormativity reinforced or disrupted?
Right. So questioning the assumption that gender identity always matches biological sex.
That signals a pretty specific intent behind the curriculum choices.
Precisely. And to really grasp the content, it helps to look at some examples the court itself detailed.
Okay.
For instance, one book, Intersection Allies, has a transgender child named Kate using they-them pronouns. It discusses gender choice, even as a guide asking what pronouns fit you best. Then there's Prince and Knight. A prince falls in love with and marries a knight. The story ends with the whole kingdom celebrating the two men's wedding day.
So, very explicitly framing same-sex marriage positively.
Exactly, as a joyous event. Another one, Love Violet, is about a young girl, Violet, who has a crush on her female classmate, Mira,
Okay.
and Born Ready. The true story of a boy named Penelope. This follows a child assigned female at birth who says, I am a boy.
Right.
The story suggests denying transition is harmful, that gender isn't tied to biology. There's even a line where a mother tells a sibling, not everything needs to make sense. This is about love.
Wow, that's quite direct.
It is. And one more, Uncle Bobby's Wedding, shows a girl reacting to her uncle marrying his boyfriend. Again, presented as joyous, with the mom explaining, when grown-up people love each other that much, sometimes they get married.
Okay, so these books are clearly presenting specific viewpoints. And then, things got complicated. Initially, parents could opt out.
That's right. At first, the school board allowed parents to opt their children out of instruction using these specific books.
But that didn't last long.
No. Less than a year later, they reversed that policy. They rescinded the opt-out.
So, parents who might have been using it suddenly couldn't. Why the change?
Well, the board's stated reason, according to the sources, was that the, quote, growing number of opt-out requests was causing significant disruptions in the classroom.
Disruptions.
And they also worried it could expose LGBTQ plus students to social stigma and isolation.
I see the dilemma there.
But it's also important they encourage teachers to actively reinforce the viewpoints in the books, and even reprimand kids who disagreed, using phrases like, that comment is hurtful.
So it wasn't just exposure, it was more like endorsement.
That's certainly how the parents who sued saw it. This created a real bind for them.
Yeah.
So faced with no opt-out, this group of parents from diverse religious backgrounds, Muslim, Catholic, Ukrainian Orthodox, plus an association called Kids First, they filed a lawsuit.
Okay.
They argued the board's policy infringed on their First Amendment right, the free exercise of their religion.
And for some, this had real consequences.
Yes, many said they felt religiously compelled to pull their kids out and send them to private school, which meant, significant financial sacrifice. It highlights the weight of this for some families.
And their legal argument rested heavily on a past case.
It did. They pointed to Wisconsin v. Yoder, a landmark 1972 Supreme Court case.
Right, the Amish case.
Exactly, which recognized parents' fundamental right to direct the religious upbringing of their children, but the lower courts weren't convinced.
They didn't buy the connection.
They largely dismissed Yoder, saying it was sort of a unique, one-off situation just for the Amish community. Not really applicable here.
But the Supreme Court disagreed and took the case. And June 27, 2025, they issue their opinion. A big one.
Absolutely. A 6-3 decision. They reversed the lower courts. Meaning they held that the parents are entitled to a preliminary injunction.
Okay, what does that mean practically?
Practically, it means the board has to provide notice to parents about these books and allow opt-outs while the main lawsuit continues. So it's a win for the parents, at least at this stage.
A significant win, even if preliminary. So why? What was the core reasoning behind the majority's decision?
The majority found that the board's policies, specifically the no opt-out part, likely place an unconstitutional burden on the parents' First Amendment right to freely exercise their religion.
Okay.
They really emphasized that this right includes that fundamental liberty of parents to direct the religious upbringing of their children. It's a core part of parental rights, they argued.
And it sounds like they saw the burden as more than just forcing someone to say something they don't believe. It was subtler.
That's a key point. The court clarified that the Free Exercise Clause protects against more subtle forms of interference, too. Citing Yoder again, the majority said policies that substantially interfere with the religious development of kids or pose a very real threat of undermining parents' religious beliefs, those can be unconstitutional.
So they're broadening Yoder, saying it's not just about the Amish being forced to go to high school.
Exactly. They're saying the principle in Yoder applies more broadly. It's a really crucial reinterpretation, suggesting Yoder isn't just some historical footnote.
And the specific content of these books played a big role in defining that threat.
A very big role. The court found these LGBTQ plus inclusive storybooks weren't just neutral info, they called them unmistakably normative?
Normative meaning?
Meaning they were designed to present certain values like same-sex marriage being universally celebrated, or gender being separable from biology as things to be accepted, even celebrated.
Right.
And, by implication, contrary values as things to be rejected. They saw it as pushing a specific moral viewpoint.
And the age of the children was critical here too, right? We're talking 5 to 11-year-olds.
Hugely significant. The court pointed out these are young, impressionable children, kids likely to just accept moral messages from their teachers without much question.
Yeah, authority figures.
Right. And this, the court said, creates psychological pressure to conform to viewpoints that might be hostile to their parents' religious beliefs. They called it an objective danger to the free exercise of religion.
So it raises that whole question about when and how schools teach values, especially to very young kids.
Definitely.
Okay, so the court finds this burden. How do they handle the school board's defenses? Because the board cited reasons like classroom disruption.
They addressed several key counter-arguments from the board and rejected them. First, this idea of mere exposure.
Just seeing the books isn't a burden.
The court said this went far beyond mere exposure because the books push viewpoints and teachers were told to reinforce them, even correct disagreement.
Okay, not just passive.
Exactly. Second, the board tried to argue this was like the government's internal affairs, citing cases like Bowen v. Roy about Social Security numbers, or Lang about federal land use, saying free exercise doesn't apply there. But the court said, nope, public schools are different. They involve direct coercive interactions between the state and its young residents, not like managing paperwork.
Makes sense. It's about direct influence on kids.
Right. Third, they explicitly slapped down the idea that Yoder was sui generis, unique, one of a kind.
They said it applies more broadly.
Yes, they stated Yoder embodies a robust principle of general applicability. Big statement there. Fourth, the board argued the parents didn't show enough actual harm yet. The record was threadbare.
Need to wait for damage.
The court said no. When First Amendment rights are involved, you don't have to wait for the injury to fully happen. The board's stated intent to use the books without opt-outs was enough to show impending injury.
Interesting. So the threat is enough. What about the argument that parents had alternatives? Private school, homeschooling?
That was also dismissed. The court essentially said you can't condition a public benefit, like free public education, on someone giving up their constitutional right to religious exercise.
Especially with mandatory schooling laws.
And the financial burden, yeah. For many families, those alternatives just aren't realistic.
Okay, so the court finds a burden, rejects the defenses. What's the next legal step? Does the burden automatically mean the policy is struck down?
Not automatically, but it triggers a very high bar for the government. It triggers strict scrutiny.
Okay, strict scrutiny. What does that involve?
Usually, if a law is neutral and applies generally, some accidental burdens on religion might be okay. But the court here said a burden of the same character as in Yoder automatically gets strict scrutiny, even if the policy seems neutral on its face.
A high hurdle for the school board.
The highest. To pass strict scrutiny, the board had to show two things: a compelling interest for its policy, and that the policy was narrowly tailored to achieve that interest.
And did they?
Well, the court acknowledged schools have a compelling interest in a safe and conducive learning environment. That wasn't really disputed.
But the tailoring part?
That's where the policy failed. The court found the no opt-out rule was not narrowly tailored.
Why not?
Because the board already allowed opt-outs for other things, like the formal family life and human sexuality units.
So they had exceptions already.
Exactly. They also accommodated diverse learning needs with separate, independent, parallel programming. This whole system of exceptions, the court said, undermined the board's claim that allowing opt-outs here would be too much of an administrative burden.
So they couldn't claim it was impossible. They were already doing similar things.
Precisely. And the court made a really pointed statement. The board cannot escape its obligation to honor parents' free exercise rights by crafting a curriculum that is so burdensome that a substantial number of parents elect to opt out.
Wow. Okay. So the bottom line from the majority. Preliminary injunction granted. The board has to notify parents and allow opt-outs for these books and any similar ones pending the final outcome of the case.
That's the core holding, yes.
Now, like a lot of these big Supreme Court cases, it wasn't unanimous. There were other opinions. Justice Thomas wrote a concurrence.
He did. He agreed with the majority's result, but wanted to add a few points.
What stood out in his opinion?
He emphasized that teaching about sexuality and gender identity to, very young children is actually a pretty recent development. He contrasted it with the historical context in Yoder.
Implying it's not some long-standing essential part of education.
Pretty much. He argued there's little evidence these specific lessons are critical for, say, civic development, unlike basic literacy or history.
Did he have a particular take on the board's motives?
He seemed to. He suggested this curriculum and the no opt-out policy were really about pursuing ideological conformity.
Strong words.
Yeah. He connected it back to a much older case, Pierce v. Society of Sisters from 1925, which basically said the state can't just standardize its children. He also pointed to some comments reportedly made by board members that were critical of parents' religious dogma, suggesting maybe traditional religious views weren't really welcome in what the board called its fully inclusive environment.
So questioning the inclusivity claim itself.
And he also suggested a practical fix.
Right.
The board could just put this kind of instruction into specific units, like they already do for formal sex ed, making opt-outs easier and avoiding disruption.
Okay, so that's Thomas concurring. But then there was a strong dissent, right? Justice Sotomayor.
A very strong dissent, yes. Joined by Justices Kagan and Jackson, they painted a completely different picture.
What was their fundamental disagreement?
Justice Sotomayor argued the majority's ruling ushers in a new reality. A reality where kids have to be shielded, quote, insulated from exposure to ideas and concepts that may conflict with their parents' religious beliefs.
So back to that mere exposure idea.
Exactly. For the dissenters, mere exposure to ideas you disagree with shouldn't be enough for a free exercise clause claim, period.
They felt the majority created a new right.
She explicitly criticized the majority for, in her view, inventing a constitutional right to avoid exposure to subtle themes contrary to the religious principles that parents wish to instill.
And they disagreed on how to read the precedents, like Yoder.
Absolutely. Sotomayor argued the majority totally misreads Yoder. She said Yoder was about the government compelling the Amish to act against their core religious beliefs.
Sending kids to high school.
Right. Not just about them being exposed to different ideas. She pointed to Ling and Bowen cases the majority distinguished as directly contradicting this thread of undermining test the majority used. In those cases, exposure to things that could gravely harm spiritual beliefs wasn't found to be a constitutional burden.
So a fundamental disagreement on what constitutes a burden on religion.
Yes, and she saw huge practical problems stemming from the majority's ruling.
For schools on the ground.
Massive problems. She warned of potential chaos for this nation's public schools.
Chaos how?
She argued that requiring notice and opt-outs for basically any lesson that might somehow implicate a parent's religious beliefs would create impossible administrative burdens.
Especially given America's religious diversity.
Exactly. The sheer multiplicity of religious beliefs, she said, and considering how subtle some of the messages were that the majority found problematic, how could schools possibly manage that?
It could get very complex very fast.
And she feared a chilling effect, that schools might just start censoring their own curricula to avoid lawsuits.
And who would lose out?
She worried materials representing LGBTQ plus students would be among the first to go, which really gets to that tension between inclusion and parental rights.
Did the dissenters see the board's actions differently too? Less like imposing a view?
Yes. Sotomayor argued the teacher guidance wasn't about imposing views, but fostering mutual tolerance and respect for everyone in the community while still respecting students' own religious views.
Trying to strike a balance.
Right. She noted schools try to ensure diverse students see themselves represented in materials across the whole curriculum. Forcing these topics into isolated inclusivity hours, she argued, would just emphasize difference rather than sameness and foster exclusion rather than inclusion.
Interesting point.
And finally, she highlighted that, democracy was working. There were local elections, appeal systems in Montgomery County. She implied this was maybe something better left to political processes than the courts.
Wow, okay, that really lays out the opposing viewpoints. It's a complex ruling with deep divisions.
Truly complex. And it highlights this profound tension we see playing out everywhere, doesn't it?
Yeah. On one side, you have parents' constitutional right, deeply felt, to guide their kids' religious upbringing.
A fundamental right.
And on the other, you have public schools trying to provide a comprehensive education, trying to foster an inclusive space for all students in an increasingly diverse society.
And this Mahmoud v. Taylor ruling really shifts the balance, at least for now. It clarifies that a curriculum seen as imposing values hostile to parental religious beliefs, especially for young kids and without an opt-out, that can be an unconstitutional burden.
And importantly, it limits the power of school boards to just say, no opt-outs because it's disruptive.
Right. It explicitly says that administrative burden claim doesn't automatically outweigh the free exercise, right, in this kind of situation. Religious freedom seems to get more weight here.
So for you listening, whether you're a parent, an educator, maybe just a concerned citizen, what does this actually mean?
Well, practically, it means parents might have a clearer legal pathway now to request opt-outs from specific curriculum materials they believe undermine their religious teachings, at least while this case fully plays out.
But it's bigger than just opt-outs, isn't it?
Oh, absolutely. It raises fundamental questions for school districts everywhere. How do they develop curricula now? How do they handle diverse viewpoints on sensitive topics? How do they balance that goal of inclusivity with respecting individual religious freedom?
We could see districts becoming much more cautious, maybe needing broader opt-out policies than just for sex ed. It's a real challenge to find that common ground.
Definitely. This decision, even being just a preliminary injunction, really reshapes the landscape of parental rights in public education. It's a critical moment for communities to grapple with what they want their schools to be.
Yeah.
And how they navigate these deeply personal constitutional questions. It fuels that ongoing debate. Who ultimately decides what's taught in our public schools?
Indeed. So maybe the provocative thought to leave you with from this deep dive is this. How do we, as a society that values diversity, foster real mutual respect and understanding for all kids in our public schools, while also genuinely upholding the fundamental right of parents to guide the moral and religious development of their own children?
That's the multi-billion-dollar question, isn't it?
It really is.
Yeah.
And it goes far beyond any single court case. It affects families, communities, educators, everyone.
Yeah.
That's all for this deep dive. Thanks so much for joining us.
Thank you.
And we'll see you next time on The Deep Dive.